So a clean break is where the financial claims are dismissed. So once the order has been made, and if it is a clean break order, neither of you can make further applications for financial support from the other. If you have inherited money and brought that into the marriage, then you may argue that that's a significant contribution that should be factored into any overall financial settlement. The court have what's called a Section 25 criteria checklist, which will set out a number of factors that the court will take into account when determining what is a fair and equitable split. If you have brought inheritance into a marriage, then you may have considered having a prenuptial agreement which would have protected that inheritance. In the event that you haven't, then you need to obviously advise me of that at the time and tell me how that money was inherited, the amount, etc. And then I can advise as to whether or not we're able to protect that. But the overriding factor is that the court will want to order something that's fair and equitable, but also to make sure that both parties' housing needs and overall needs will have been settled. So it may be that that is added into the matrimonial pot for division. So if you receive inheritance post-separation, you can argue that that's a post-separation asset and it should be ring-fenced. However, the court have an overriding objective to make sure that both parties' needs have been met from the overall settlement. And it may be the case that the court thinks it's fair for that inheritance to be added into the pot because it's a resource that's available to one of the parties. So it could still be treated as an asset, although there's a reasonable argument to say it should be a non-matrimonial asset, largely because it's inheritance that's received post-separation.